Self-defense rests. Let's lay it down. Gonna dig deep. Wave that verdict round. The defense rests. Time to analyze. With the evidence, we'll unveil the crime. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Oh, well, you told me 3 weeks, so I went ahead and typed it in for 3 weeks. But I've changed it on the original. So yesterday, the state indicated they may have another witness or at least exhibits. And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes.
So I thought we'd take that up before I brought the jury in and had to send it back out.
Yes, Judge. The state intends to introduce a certified copy of the order from the Circuit Court in Bristol, Virginia, which ordered Hunter Wood involuntarily committed to the mental hospital over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a letter dated January 10th, 2025, which is from the Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is a I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the Circuit Court of Bristol, Virginia.
We have no objection, Judge.
Okay. So what I intend to do, and then after that, do you think you'll have any proof?
No, Your Honor.
So what I'll do is I'll bring the jury in, admit that, and the next number of exhibit, then you can rest in front of the jury. And then I'll have to send them back out so we can take up some matters out of the present. All right, we bring the jury in if we're ready.
Everyone stand, please. You may be seated. Thank you.
All right, General, call your name. Oh, wait, before we do that. Ladies and gentlemen, yesterday when we left, I gave you certain admonitions. Do any of the jurors have anything to report with regard to those admonitions? If you do, raise your hand. Let the record reflect none of the jurors raise their hand. All right, General.
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he.
Hello, welcome back all. Hello. Sorry, I had to finish off one stream and another one and juggle a bit, but all good. Okay, so day 7. Yesterday we ended with the forensic examiners. And it looked a bit spicy, I must say. A bit spicy. So, what did we find out? Well, so the autopsy findings indicated the cause of death was determined to be homicidal violence. Now, the autopsy was impacted by the level of decomposition, which complicated the examination, and because it could obscure any bruises or contusions, and hinder the ability to draw sufficient toxicological specimens. And it didn't show any soft tissue injuries, which may have been influenced by the level of the decomposition. The position that she was found in, upside down in the trash can, raised concerns about positional asphyxiation. And the forensic pathologist noted that if she was alive when placed in the trash can, this positioning could compromise her airways. And there was the spiciness became over the argument whether or not the defense attorney was saying, how could you prove that she was alive still when she was put into the bin? And whilst there was no, like, you can't, had it been something soft that had fibers and stuff like cotton wool, if she'd wrapped cotton wool around her face, then there would have been fibers in her lungs, and that would have been, something that could have proved that. But why even put foil around her head? What's the point? Why would you do that? If the baby is unalive, would you not just wrap her neatly in a blanket? Although I wouldn't put a baby in a trash bag in a bin anyway, but, that's just me. I don't understand the reasoning behind the foil, other than to stop the breathing. But also, if it was an accident, why hide it? Why hide it for so long? Why go to this enormous effort of all these lies? And, you know, the few things that I picked up the other day watching it back over again, you know, she's out. She's saying, she blames, first she says it's baby daddy. She's with Ethan, which turns out to be a lie. Then she blames mum. Mum took the baby. Won't tell me where she is. But then she decides she's going to go on a family outing to the Blowhole and all this place with her mother and Hunter, and have a family outing with the person that is holding your daughter and refusing to give her back. That doesn't make sense either. Then it was hinted at, I think, was it Christine, or I wrote them all down, but there's 4 of them. Blames. Remember, it's somewhere. Yeah. But this just reminded me here, the Hunter, the one that was admitted to the psych hospital only, you know, a few weeks before this trial. Apparently the reason behind that is because he was receiving death threats because of his involvement, or supposed involvement, in this crime. Because you remember, he came along when Evelyn was missing. So yeah, and yeah, he was getting threats and all sorts of stuff on Facebook because of his alleged involvement, and that's pretty much what tipped you over the edge. What was the other thing? What else did I pick up? What I can't understand either is why the cadaver dog didn't pick up the baby on their when they did their investigation. They took a cadaver dog there, and yeah, nothing. There were no signs of natural disease. She was perfectly healthy, and nothing to reveal as contributing factor to her death. The findings were supported by the investigative summary and the circumstances surrounding her death, including the manner in which her body was found. There was no evidence of abuse, no signs of physical abuse such as broken bones or prior injuries. So the autopsy concluded that Evelyn's death was due to homicidal violence with no evidence of natural causes or abuse found during the examination. Yeah, so this is where we pick up from. I have no idea who their next witness is, but I would think they were coming close to, you know, hanging up their hooks. I would be thinking that they would be resting fairly soon, given it's day 7 and they've had the 2 medical examiners. So let's see, shall we?
He's been involuntarily hospitalized at that facility. If we would offer that as the next exhibit in this case. 261, I believe.
261.
Yeah, absolutely.
That'll be exhibit 261.
I did. I was juggling 2 streams, 2 feeds. But I did it.
All right. Go next.
Judge, stay with rest.
Oh,
All right.
there you go. What did I tell you? It's my ESPN.
Everyone stand, please.
Rest. There you go. Wacko the Diddlo.
may be seated. Thank you.
Mr. Scott, you have a motion?
Oh, a motion for acquittal.
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts.
Told ya.
Just briefly, I'll go through them. As it relates to the first 3 homicide counts, the state has failed
Denied.
to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various, although she stated that she believed it was asphyxia, she later under cross-examination admitted it could have been a SIDS death. She admitted that it could have been a heart issue,
She did
or it
not.
could have been a laryngeal
Give up.
spasm that caused the death. She really
Liar.
couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she
Positional
did
asphyxia.
answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count 1 in premeditation, there is no evidence whatsoever in this case of premeditation. So those are the 3 murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect his health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion.
All right. So does anyone want to add to my vote from his cross-examination of the medical examiners yesterday? He got 1 vote from me to go towards the dipshit award. Taking nominees right now. Anyone? Hands up. Voting for defense attorney. 1 vote each. We have currently 2 for the defendant, 2 for the defense attorney, 1 for the cameraman. Do you like my emojis? Lie, pants or fire. Come on, speak now or forever hold your peace. Anyone? You're not wasting a vote. You can have another one tomorrow. Oh, did I unstart that or did I start? Oh. Unstart it. Okay, cool. All good. Don't mind me.
False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those, but I will leave those for now, but I do move for a judgment of acquittal without further argument.
Denied.
And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
I'm a brief, Judge. Of course, the court reviews this motion in the viewing the evidence in the light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket, and then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation is at least shown through the physical evidence in this case. As far as the remaining counts showing the cause of death, both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
All right. Of course, as Mr. Scott and the general has stated, in viewing the evidence in light of the Rule 29 motion for judgment of guilt, the court's required to view the evidence in light most positive to the state. And looking at these charges and the proof through that lens, with regard to count one, the premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, you couple that with the voluminous amount of evidence where the defendant was giving different stories as to where the child was, as to how the child was doing. When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that day, it was story after story about where the child was. The defendant appears to have moved on to other things. And I think when you take all that evidence and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But of course, of the opinion, the state, when looking at that proof and what most favorable to the state, that they had put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think we've taken in a lot most favorable to the state the fact that that child
Neglect, maybe. I don't know about abuse, but then there's a fine line, isn't there? What's the difference?
I think the jury can look at that.
Is neglect a form of abuse? Yeah. Yeah. Where are we in? Is it Tennessee? Where is this case? Is it Tennessee? 10? I don't know my county initials yet. It is Tennessee, isn't it? I might have a look and see what their definition of that is.
And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy dirty toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. I think that taking the lot most favorable to the state, those two counts would survive the Rule 29 motion, and I'm going to deny the motion with regard to those two counts. With regard to the tampering with evidence and false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages.
Welcome, Patty Clark.
Social media posts.
New subscriber, thank you.
When you take those as a whole and view them in a light most favorable to the state, I think those are issues the jury can determine and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right. In that case, we have to go through the Bowman versus State questioning. And I'm going to hand this down and let you do that.
Judge, for the purpose of the record, would you like her to come to the?
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Scott.
Megan, I want to ask you some questions about my representation of you and explain to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes,
Okay. And part of that, I've talked to you about, you have the right to testify. Is that right?
yes,
And if the jury can't hold it against you if you don't testify, you understand that?
yes,
You understand you have a right not to testify?
yes,
And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
yes,
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
yes, I have.
Do you want to testify?
No,
I think I covered it, Judge.
Mhm.
Approach.
Ugh.
All right. We got to
Mm.
No. I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I got to send the jury out so we can finalize the charge and give the parties time. Because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. been my experience, especially after lunch, that fewer of them, not all. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge, so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we'll bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I will finalize it and send it out. That's the
Yes, sir.
process going forward. And during this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for the closing argument. Okay, so we need to bring the jury.
Bring the jury.
And I need to give the jury.
Sullivan County.
Yes, sir. I was going to ask about that. I forgot.
I didn't.
Hot mic. What you gonna do?
Everyone stand, please.
Oh. Very loud.
You may be seated. Thank you.
Oh, I have to turn that down. Far out.
Okay, ladies and gentlemen, one thing I omitted to do a moment ago.
Whew.
Yesterday, during Dr. Malushnik, did I say that right?
Yes, sir.
At the very end of her testimony, she answered a question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? I'm going to instruct you that last phrase, you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Can everybody put that murder in some other way out of their mind and not consider? If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Been at rest.
All right. Ladies and gentlemen, where we are now is the proof is closed, but it is not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge.
Hang on. Did he just say the defense isn't? No. Hang on. Back that track up. Hang on. Oh, hold on just one. Yeah. Let's play that again.
Does everybody understand that? Can everybody put that murder in some other way out of their mind and not consider? If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Been at rest.
All right.
No.
Ladies and gentlemen,
No
where we are
defense.
now is the proof is closed, but it is not time
Wow.
for you to begin deliberating or talking
Hang on.
about the case.
There's another one. Yep, she's cray. I got ones for everything.
We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow
Yeah.
along and you'll have that for your reference. While
Well, why fill in the gaps? You're only going to reduce the doubt by answering any gaps that the state haven't filled. Plus, Jesus, guilty AF. So, how do you defend that? Just saying.
This will also, and what will happen is.
I like the
45 minutes
twitch
to
to
an
his
hour.
eyebrows.
I'll get all the notebooks made.
Judge, you can get Botox to
Give
fix
the
that.
lawyers
Promise.
time to organize their thoughts for closing. When we come back, I will hand out the notebooks and I will read you the charge.
Ooh, we get notebooks.
It will be painful, and I apologize for that, but that's the way it is. And then we'll go straight into argument. Okay? So
Straight into
I
closings.
apologize for the length of the break, but just bear with me. It's necessary. Okay? You'll go with the officer.
Everyone stand, please.
Oh, you bailiff. The fuck? Oh, they actually shut the whole stream down to discuss the charge.
You may be seated, please.
All right, we'll be in recess. We'll probably take.
Told ya.
Court stands in recess.
Bye-bye now. Let me just, I'm just having a little bit of a sticky nose. Who? Who can we look? Did anyone see? Do you remember me talking about the rose petal murder trial that's started yesterday? Law and Crime are calling it the Twisted Secrets murder trial. I think that's about a wife that was unalived with a sharp forced object. But the one I'm waiting for is, oh, Courtroom Confidential has an interview with recovery addict. All right, I have because I'm so goddamn clever. I'm going to have to bring it up on Canva because I haven't had a chance to save it yet. Well, it's saved, but it's not in the format what I needed, and I couldn't convert it, so we will present from Canva. Simple as that. Move you over there. Thank you. Open you, make you full screen, and share. There we go. Definitions of child abuse and neglect in Tennessee. Abuse exists when a person under age 18 is suffering from, has the state, oh, look at that. I've got a green thingy. Oh, that's a bit fancy. What does that do? Ooh, ooh, ooh. Oh, no, go back. Oh, arrow that way. Arrow that way. Let's go up. No, that's new. Sorry. Small things. Okay, serious face, Jody. Come on. All right. Abuse exists when a person under the age of 18 is suffering from, has sustained, or may be in imminent danger or suffering from or sustaining a wound, injury, disability, I've been abused, or physical or mental condition caused by brutality, neglect. Oh my God, I have been abused, or other actions or inactions of a parent, relative, guardian, or caregiver. I wonder what Australia's definition of abuse is. Severe child abuse means any of the following: the knowing exposure of a child to, or the knowing failure to protect a child from, abuse or neglect that is likely to cause serious bodily injury or death, and the knowing use of force on a child that is likely to cause serious bodily injury. Specific brutality, abuse, or neglect towards a child that, in the opinion of qualified experts, has caused or will reasonably be expected to produce severe psychosis, severe neurotic disorder, severe depression, severe developmental delay or retardation, or severe impairment of the child's ability to function adequately in the child's environment, and the knowing failure to protect a child from such contact. Ready? Green arrow? That way. Sorry. The Commission, I'm going to have to start working Canva every time. Why am I saving this and putting it onto my hard drive and filling up my hard drive? And this is awesome. And you can read it. The commission of any of the following acts towards the child: trafficking for a commercial act, grape, aggravated grape or grape of a child, aggravated sexual battery, promoting paid actions, sexual battery by an authority figure, aggravated grape of a child, statutory grape of an authority figure, incense, aggravated child abuse, neglect or endangerment, aggravated sexual exploitation of a minor. The knowing failure to protect the child from the commission of any of the preceding acts towards the child, knowingly allowing a child to be present within a structure where the act of creating methamphetamines is occurring. Yeah, fair enough. Knowingly or with gross negligence, allowing a child under age 8 to ingest an illegal or controlled substance that results in the child testing positive on a drug screen, except as legally prescribed. Knowingly allowing a child to be within a structure where any of the following controlled substances are present. Yeah, hang on. Knowingly allowing a child to be within a structure. I wonder if that goes on to a confined space. Significant injury means bodily injury, including a cut, abrasion, bruise, burn, disfigurement, physical pain, or impairment of the body. A substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, protracted loss or substantial impairment of function of a bodily member, organ, or mental faculty. Neglect. Dependent and neglected child means a child to whom any of the following apply. Okay, so that first bit must have been physical abuse. So they're two different definitions. Dependent and neglected child means a child to whom any of the following apply: who is without a parent, guardian, or legal custodian, whose parent, guardian, or persons with whom the child lives by reason of cruelty, mental incapacity, immorality, or depravity is unfit to care properly for the child. I'm sure we could tick a few boxes here. Who is under unlawful or improper care, supervision, custody, or restraint by any person, corporation, agency, association, institution, society, or other organisation, or who is unlawfully kept out of school, whose parent, guardian, or custodian neglects or refuses to provide necessary medical, surgical, institutional, or hospital care. Yep. Who, because of lack of proper supervision is found in a place the existence of which is in violation of law. Yep. Who is in a condition of such want or suffering or is under such improper guardianship or control as to injure or endanger the morals or health of the child or others. Yep. Who is suffering from abuse or neglect. Yep. Who has been in the care and control of one or more agencies or persons not related by blood or marriage for a continuous period. Okay, I think that was the end of it. Yes. Yes, I'm going to have to start using Canva more for that, because I save them and then have to find them and upload them and present them, and they come up these tiny little things and then I can't read them. So that's awesome. Yeah. 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 I'm working on the timeline. This is what I do whilst I'm watching. Yeah, I cut and paste pictures and upload, ready for the next thing to come along. But the next trial starts the 24th. All right. Well, we'll need to find one in between then, won't we? Because I don't reckon this is going to take very long. Just quietly. So we'll have closings this afternoon, and I reckon we'll be at verdict watch by the end of the day. Okay. Now, who can we stalk? Of course. Day 2 of that has just started at Twisted Secrets, Rose Petal. All right. Let's stalk Steve, shall we? All right. Hello, y'all. Anyone home? Now, I do believe I have I thought I had a I must have used it. You guys, have you checked your membership anniversaries? Have you hit the what did we do? Yeah, you should have hit the 2 months by now. So if you go into the in chat, okay, as you can see here in the chat here, if you go into the bottom where it's got the money sign, it will drop down one extra box at the bottom that says like free anniversary message or something like that. Membership anniversary. I can't remember what it says, and it will come up on the screen on here like a super chat. And we get to shout you out. I think it's every month though, like, oh, it was disgusting, wasn't it? Filthy. Filthy, filthy, filthy. Just, well, what is it? What time is it over there? 10? 10 past 10? Is that right? Oh, God. We've got 2 hours. Huh? Well, I don't know how to juggle. And I'm not really sure what else I can do to entertain. Not very exciting, am I? Did anyone? No one's even replied to my, my message. Oh well. All right. What else is on? Let's have a look at. Let's see what law and crime have to offer. Geez, I'm hot in here. I have to put my aircon on, I think. It's getting hot in here, so take off all your clothes. I ain't getting so hot. I'ma take my clothes off. Has Judge Fleischer come back on yet? Excuse me. Oh. All right. That's what. Bit of Anjanette Levy, Crime Fix. Why not? These two look very attractive, and I think they make a beautiful couple and should procreate. Okay.
Are in jail accused of endangering their newborn twins by not feeding them. I lay out the disturbing allegations out of suburban Philadelphia. Welcome to Crime Fix. I'm Anjanette Levy.
Hi,
Newborn babies, they need a lot of care. They eat about every 2 hours or so. And when they're born prematurely, they need even more care and feeding. But the district attorney in Bucks County, Pennsylvania, outside of Philadelphia, says 2 parents there were not doing what they should for their newborn twins. Courtney Soikas and Marcus Medella are in jail in Bucks County, charged with child endangering and criminal conspiracy. They are the parents of these twins born prematurely last October. Bucks County DA Jen Shorn, she's going to be here with us to talk about the case in a little bit. The allegations in this case are quite simple. The DA says Soikas and Medella were not feeding these little twins. And if you
Soikas and Medella. What did they name their twins, I wonder?
If you've ever had a baby, this sounds unbelievable because when babies are hungry, they cry and they cry a lot. Now,
unless you don't feed them for a long time, then they stop crying.
Let's go back to the very beginning. The affidavit states that JV1 and JV2, those are the babies, that they're twins. They were each born premature at 32 weeks on October 7th, 2024. Both were held in the neonatal intensive care unit until they were allowed to be released to their parents. On or about December 11th, 2024, JV1 and JV2 were brought into the hospital after both twins missed 4 medical appointment visits each. Each baby was under the first percentile for their age. Wow.
Jeez.
So this allegation, it's stunning. These are babies that were born prematurely. They were in the NICU and they didn't weigh very much at all. And the claim is that they didn't gain very much weight while in the care of their parents. The affidavit continues. Following the twins' birth and ultimate release from the NICU to live with and be cared for by the defendants, their parents, the defendants, failed to bring their children to at least 4 scheduled medical appointments. The twins were recommended to have regular weight checks, which were scheduled for November 12th, 2024, November 13th, 2024, November 19th, 2024, and 12/9, that's December 9th, 2024. On December 11th, 2024, defendant Soika attended a checkup appointment for the twins. Both JV1 and JV2 were found to be malnourished and were sent to St. Christopher's Hospital, thus originating the CWIS referrals. The affidavit discusses the baby's weights in ounces, but I'll talk about it in pounds for you. The babies were born on October 7th. Baby number 1 weighed just 4.16 pounds. That's really, really tiny. Baby number 2 weighed 3.74 pounds. But when their mom took them to the doctor 2 months later on December 11th, the prosecutor says that baby number 1 weighed 5.78 pounds and baby number 2 weighed 5.04 pounds.
That's what I was born
The babies were taken to St. Christopher's Children's Hospital in Philadelphia, where they were monitored and fed regularly. A doctor wrote in her report about the babies, as both JV1 and JV2 presented with very poor weight gain, including weight below the first percentile, with no other symptoms of illness, and have improved significantly with only formula feeding by mouth. Their evaluations appear to be most consistent with insufficient caloric intake at home. This would not be consistent with mother's history of patients receiving 4 ounces of formula every 4 hours, as described by SCHC staff. Additionally, patients' insufficient weight gain could have been addressed earlier if the twins had followed up with their primary care pediatrician as scheduled. Given these concerns, the evaluations for both JV1 and JV2 would be consistent with neglect and medical neglect. Following an investigation, Courtney Soikis and Marcus Medella were charged with child endangerment and criminal conspiracy. The affidavit states the defendant did conspire and agree with Marcus Medella that they or one or more of them would engage in conduct constituting such crime or crimes, and in furtherance thereof did commit the overt act of not feeding JV1 and JV2 or caring for them in an appropriate manner, rendering both to the hospital for further care. I want to bring in Jen Shorn. She is the district attorney in Bucks County, Pennsylvania. Jen, one of the things that kind of surprises me about the allegations in this case is the fact that babies get up every 2 hours to eat. Preemies, I've never had a preemie at 32 weeks, but gosh, I can't imagine that they maybe don't wake up a little more than that. And they would cry a lot. They would be starving and hungry. So this, the first many weeks of these babies' lives would have been horrific.
I can't even imagine the suffering they went through. Obviously, as you indicated, babies give cues when they're hungry, and the medical professionals they diagnosed that the fact that the babies were giving appropriate hunger cues and they clearly were being ignored. And the fact that these children were so malnourished, I mean, this is a case of gross neglect and medical neglect because the parents failed to even just take them to the required pediatric appointments, which would have flagged the lack of weight gain. It's appalling.
Are you able to tell us, did these parents have any explanation for missing these appointments? I mean, when you have a newborn, that's kind of part of the whole thing. You go to the doctor a lot when you have newborns. I mean, you're there every week or so, it feels like, or every week and a half.
You're so right. And the pediatric physicians and their practices, if a parent forgets an appointment, which can happen, they proactively seek out the parents of newborns to make sure that a missed appointment is rescheduled immediately. So it takes effort to ignore repeated appointments. It was at 4 missed appointments. And then finally in December, after the babies were born in October, mom finally took them in, and there's no explanation as to why she was failing to feed her children, why her husband was failing to feed the children, and why they were missing these medical appointments. I suggest that she probably knew it would reveal the case of gross neglect. So I just praise the pediatricians and the medical professionals at St. Christopher's Hospital for catching this case of severe neglect.
But you say there's no explanation. I mean, the doctors had to have questioned her. I mean, she's claiming in the affidavit, it looks like she's claiming she was feeding them, but obviously they're not gaining weight. And then the hospital's like, well, yeah, now we have them and we're feeding them regularly and they are gaining weight. They are thriving. I mean, gosh, could they just not afford the formula? Was she, I don't know. Was there any talk of this?
No, there was no indication that the parents were lacking their daily needs. Their daily needs were met. So it's clearly a scenario where the medical history that the parents were providing to the medical professionals were lies, that they were not being truthful. The babies are thriving, thank God, in foster care. And so there is no explanation. And sometimes it's hard to wrap our brains around how this type of child abuse can occur. But this is severe neglect from, just failing to meet the baby's basic needs, but medical neglect. God only knows what would have happened had the medical professionals not seen those babies in December. I fear what would have happened, especially as it relates to one of the twins.
And correct me if I'm wrong. I mean, it looks to me from what I'm seeing on social media that this couple had older children as well.
Yes. I mean, I have to speak in general terms. The other thing that's noteworthy is they're not young. The mother's in her 30s, the father's in his 40s. This is not a scenario where you have very young parents who don't know better. And certainly we know there's training and awareness from the moment you leave the hospital, even individuals who are young or maybe of lower IQ, they're made aware of what the basic needs that basic needs that need to be met for their children. There's no excuse. It's not logical. It is actually just unimaginable to think of why, but certainly we know these babies suffered.
You've charged this as a criminal conspiracy. So that to me sounds like there was an agreement among them, according to the charge that's been filed, to not feed the babies. Is that what you're saying here?
Yeah. So, I mean, we obviously, you're spot on for conspiracy, there's usually circumstantial evidence of an agreement and then acts in furtherance of that conspiracy. We don't have to prove an actual discussion occurred, but both of these parents had a duty to act and both of them failed that duty. They failed their babies. And so it's circumstantially quite evident that they conspired to neglect their children. I mean, plain and simple. If one parent is suffering from a medical, diagnosis, depression, or for other reasons is unavailable to act, certainly the other parent should step in. So there's no explanation other than they acted in concert with one another. And this is just appalling conduct. It's senseless.
Yeah, it's so sad. I'm glad the babies are thriving and that they survived. Jen Shorn, thank you so much.
Thank you. I appreciate it.
I want to turn now to Matt Mangino. He is a former prosecutor in Pennsylvania and an all-around good guy. Matt, what are your thoughts on the charges in this case? We have child endangerment, and then we have a criminal conspiracy charge. That to me almost sounds like an agreement or a plan to not feed these babies. Am I wrong?
No, I think you're right. When you hear that word conspiracy and that charge conspiracy, it's usually an agreement between one or more people to carry out some sort of crime. And so here we have endangering the welfare of children. This is a horrific case, but it meets the elements of endangering the welfare of a child. It'll be interesting to see how they try to develop this conspiracy that they planned to endanger the welfare of these twins.
Yeah, I mean, these are teeny tiny little babies. I mean, these aren't just normal average babies. They were born prematurely. They were in the NICU. I mean, they're preemies. I'm just like, whoa. I mean, the allegation that you're not feeding them enough and that you're doing it intentionally and that there's an agreement to not do that. That's a pretty horrific and stunning, allegation.
Well, it is. It is a stunning allegation to suggest that this was some sort of planned crime to not nourish, feed, care for these infants appropriately, and ultimately cause them to be in ill health or cause their death. I mean, that is striking. As a prosecutor, I actually prosecuted a case where it was very similar, except one of the twins died as a result of it. And we looked at this case very carefully. We looked at the background of the mother and father, who both had some intellectual limitations, but ultimately, it's a serious crime. It's a horrific crime to actually either intentionally or unintentionally starve your infant twins.
I want to turn to the flip side of this now, because it appears, from what I can tell, that this couple has other children. They have older children. So, you would think that they would know how to feed babies, that they know the drill. They've been through this before. But how do you defend this case? How do you go about defending it then? Because basically the DA is saying this could have been prevented had you just gone to your well check appointments and just taken the babies to the doctor like you were supposed to.
Well, yeah, I mean, one thing that I would look at is obviously these appointments were missed. And was it a situation where the parents were panicked because maybe the twins weren't thriving the way they should be, and they didn't want to bring the children to the doctor in the hopes that they could, get over this and ultimately bring them there? Intentional harm in this situation, I think, is difficult to prove. Ultimately, they brought the children to the hospital, but having missed 4 appointments prior to that, where they could have received some help, some guidance, maybe even the temporary hospitalization of the children to make sure that they were getting the nourishment that they want. So, I'm not sure that an intentional act is here, other than they did not provide appropriate nourishment to these children, to these infants, which caused their serious health problems.
I just keep going back to the fact that they had other children. They may not have had premature twins, preemies that had been in the NICU, but they had other children from what I'm seeing on the internet and everything. So it just seems to me maybe this is going to be an uphill battle for them, but I don't know. There's a lot we still don't know about the case.
Well, right. And it is a very serious case. This is a felony 1, which in Pennsylvania is punishable by up to 20 years in prison and a $50,000 fine. And the reason that it is because it sort of ratchets up depending on the circumstances. So this is normally a misdemeanor 1, endangering the welfare of children. But if you put them at risk of death or serious bodily injury, and they're under the age of 6, this rises to a felony 1, the most serious criminal charge in the Commonwealth of Pennsylvania, obviously, other than murder. So this is a serious situation for these parents.
It really is. And we will keep an eye on it to see how it pans out. Matt Mangino, thank you so much.
Thank you.
And that's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much for being with me. I'll see you back here next time. Stephen Stearns, the man.
All right. Anna, did you see yesterday afternoon's testimony with the medical examiners or not? Do you want me to rerun some of that, or what would you like me to do? I've got 2 hours to kill, so I can rerun some from that trial. I can put bits and pieces up, or I can just start another stream and come back, because I do have some work to do. So any preferences on what you would like to watch? Let's have a look. Do you want to have a look at the The Twisted Secrets murder trial. Yeah. Could always watch Karen Reid. Sorry, Tricia. What about body language assessment?
Little baby Evelyn, a blue.
You want to watch body language assessment analysis while we're waiting? Anybody? No? Dust. All right. I shall put it on and I'll be here in the background doing some work. So if you need me, just holler. Holler. Let's get some settings right. Okay. And go.
Blue-eyed, blonde-haired bundle of absolute joy was born in Tennessee. Her dad was in the military and didn't have a relationship with her mom, Megan Boswell. So Megan was a 17-year-old single mother, but she seemingly had some help. Evelyn and Megan lived on the Boswell family compound with Evelyn's grandparents, Tommy and Angela, and Evelyn's uncle, Tommy Jr. At some point in December of 2019, Evelyn went missing, but no one reported her gone until February of 2020. It was her grandpa, Tommy Boswell, who called police, not her mother. When the investigation began, Megan's story allegedly changed and turned out to be false. She reportedly said Evelyn was with Grandma Angela and her boyfriend.
I sit here and ask you 10 minutes what people want to listen to. Yeah. All right then. What do you want me to do? Do you want to re-listen to some of yesterday's testimony, or do you want me to just, maybe I might just restart again at when the court comes back? That might be a better. And congratulations, you found it, Anna. Yay! 3 months already. Wow. Wow. I can't believe I've been monetized for that long. I think they've paid me this month. Congratulations. And suffering your jocks at the same time. All right. I will start another one, I think, because 2 hours is a long time. And I can get a lot of work done. Oh, I'm happy with whatever you'd like to listen to. I don't mind. I really. Do you want to have a listen to the new trial that started yesterday? I can put day one of that on if you like. The Twisted Secrets murder trial. Here we go. This is. Oh, hey, sweetheart. Hello. Yes. And I can tend to some demanding pussies. Day two. I want day one. Pre-trial. Day two. Where is it? I did threaten Karen Reid trial. Where the hell's they went from pre-trial to day 2. All right. And they haven't started yet today. I can step away for Karen Reid. It's actually quite interesting. Yeah. That's the one. All right. Let's go back. Go back.
Caitlin Ford.
Go back.
Ford, good morning.
Good morning.
Oh. I thought that wasn't.
Could you tell the jury where you currently are employed?
I work at Albuquerque Police Department.
And what do you do for them?
I'm a crime
it's
scene
just
specialist.
started, has it?
And how long have you been doing that for the Albuquerque?
Hang on. It did. It just started this very second. Okay. There you go. So this is about Zachary Hughes been charged with the murder for allegedly stabbing veterinary technician Christina Parcell to death in Greer, South Carolina in October 2021. Parcell's ex-boyfriend, John Mello, has also been charged with harassment and conspiracy for releasing explicit photos of Parcell. If convicted, Hughes could face life in prison for the shocking crime. And I believe he is a pianist, and he put rose petals or something around, because I looked into this ages ago. So we'll put this on and I'll see if I can find any background info, and then I'm going to sit here and do some work whilst you're watching, because I got shit ton to do before Saturday. A shit ton. And there isn't enough hours in the day. So you can go back over there. And you can go full screen. And come on, mouse, play.
Please stop at the end of the bench. Place your left hand on the Bible. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Please be seated. Please state your name for the record.
Caitlin Ford.
Ford, good morning.
Good morning.
Could you tell the jury where you currently are employed?
I work at Albuquerque Police Department.
And what do you do for them?
I'm a crime scene specialist.
Okay. And how long have you been doing that for the Albuquerque Police Department?
About 2 years.
Where were you working in 2021?
Here at Greenville County Forensics.
And what?
Actually, did you hear why we're on such a long break, Rita? State rested, defence rested. So they're finalising the charges and the jury instructions, and they're coming back after lunch with closing statements, closing arguments.
As a forensic technician.
And could you describe for the jury, what kind of actions you take, what your duties are as a forensic technician when you were with the Greenville County Sheriff's Office?
So we respond to crime scenes within the county limits. Depending on the crime scene, we can do things such as take photographs, process for fingerprints, collect evidence, just depending on what that specific scene is.
So it's safe to say that collection of evidence on specific crime scenes is one of your primary roles.
Correct.
And same thing would be taking pictures in accordance with that.
Yes,
Were you in that role on October 13th of 2021?
I was.
I
How were you
didn't-
involved?
I didn't edit the TV interview. I played the full uncensored one.
With the present case specifically related to the crime scene on October 13th of 2021.
I was the primary crime scene investigator for this case.
So you were tasked with processing the home at 122 Canebrake.
I was.
And in your role as a forensic technician, are you subjected to trainings and continued education for that role?
Yes, I have my bachelor's in science and forensic and investigative science. In the past, I've held certifications in bloodstain pattern analysis.
No,
and
I know you didn't mean me.
Analysis, and I am currently part of a specialized unit called the Major Crime Scene Team in Albuquerque.
I didn't realize
that
they had cut
responds to
hers.
all
I haven't
homicides
seen it.
and officer-involved incidents.
Approximately how many crime scenes do you process in a given year?
I would say over 400.
So can you describe for this jury, specifically related to October 13th of 2021, what your process was on arriving at 122 Canebrake and steps you took with your specific role?
So when I arrived on scene, I met with officers and detectives on scene just to get a brief run through of what was going on. After that point, myself and officers did an initial walkthrough of the scene just to see the layout of the house and where things were located.
So when you were doing the layout of the house and going through there, did you take photographs of the outside of the house?
Yes,
And if I show those to you, would you recognize them?
I would.
I'm going to show defense counsel what is State's Exhibit 69 through 84. First witness was 69 through 84. Could you take your time, review those, and let me know if those are the pictures that you took of the outside of the Canebrake home?
Yes, these are the photographs that I took of the exterior.
So that was what the Canebrake home looked like when you arrived on the scene October 13th of 2021?
Yes.
Your Honor, at this time, the state would move into evidence State's Exhibit 69 through 84.
Counsel? No objection, Your Honor. All right. 69 through 84 comes in.
Ms. Ford, I'm going to go through these with you. And if you like, I have a pointer here. If you need to use it. Starting with State's Exhibit 69. Okay. What is State's Exhibit 69 a picture of?
So that is a photograph of the gray Lexus that was parked in the driveway.
were you able to identify in the course of the investigation there who was driving the gray Lexus that day?
Yes, it was the victim.
Showing you State's Exhibit 70.
That was the red Mercedes that was parked in the driveway as well.
Who was driving that vehicle?
Mr. Post.
State's Exhibit 71.
That is the front side of the residence showing the windows along the front door.
72.
That is a close-up of the front door.
73.
That is a photograph of the exterior side of the front door handle.
74.
That is the gate on the right side of the residence. If you're standing facing it from the roadway, just showing the gate into the backyard area.
So is that, are you staring at Canebrake Drive there?
Yes,
Is that the red Mercedes in the driveway?
yes.
75.
That is the photograph of the back or side door of the residence.
And at this time, had the initial deputies already gone through the house?
Yes,
76.
that is a photograph of the backyard.
And so would this be looking to the opposite side that we were just reviewing where the driveway,
Yeah.
away from the driveway?
Yes, away from the driveway.
77.
That is a photograph of you standing at that gate that we just viewed, looking at the end of the the end of the backyard.
78.
That is just showing a close-up of the creek and what you can see from the backyard.
We're going to go to State's Exhibit 80.
That is the gate on the opposite side of the house, leading into the backyard.
That's looking into the backyard.
Yes,
81.
that is just showing another close-up of the backyard along with the second-story porch.
82.
That is a photograph of the nook that is underneath the second-story porch in the back side of the house.
Now you called it a nook.
Yes,
If I'm standing on Canebrake Drive, can I see somebody under there?
no, you cannot.
And if I'm standing, let me go back to State's Exhibit 78. In the backyard there, what was the collection of houses like, I'll say, with relation to the backyard of the house?
It was
Or how close in proximity were other neighbors?
They weren't that close. They were separated by both of their own backyards, including that woodsy area and a creek.
Go to State's Exhibit 83.
So that's just another close-up of that nook area.
State's Exhibit 84.
And now we've moved out into the front yard, and that's just showing a broader photograph of that gate on the left side of the house.
So from where you're standing there, taking State's Exhibit 84, could you see into that nook there that we were just reviewing?
No, you cannot.
After reviewing the outside of the house, did you thereafter go inside the house and do the same process of taking photographs and reviewing the inside the house?
Yes,
If I showed you those photographs, would you recognize them?
yes.
I'm going to show defense counsel what is State's Exhibit 40, excuse me, 40. Let me get this right. States 38 through 62 and states 63 and 66.
of second-degree murder, attempt to commit.
Your Honor, count 18, was that redacted out?
Seated. Thank you.
All right. All right. In the criminal court for Sullivan County, Tennessee, at Blumble, State of Tennessee versus Megan Boswell, defendant, case number S72869, date February 3rd through 2025. Count 1, first-degree premeditated murder. Count 2, first-degree murder in the perpetration of a felony. Count 3, first-degree murder in the perpetration of a felony. Count 4, aggravated child abuse. Count 5, aggravated child neglect. Count 6, tampering with evidence. Count 7 through 17, false report. Count 19, abuse of a corpse. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Jury instructions. Members of the jury. Count 1 of the presentment charges the defendant Megan Boswell with the offense of premeditated first-degree murder. This offense embraces the lesser included offenses of facilitation of premeditated first-degree murder, attempt to commit premeditated first-degree murder, facilitation of attempt to commit premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, child neglect, attempt to commit child abuse, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 2 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser included offenses of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, attempt to commit child abuse, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 3 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser included offense of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child neglect, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 4 of the presentment charges the defendant Megan Boswell with the offense of aggravated child abuse. This offense embraces the lesser included offenses of facilitation of aggravated child abuse, attempt to commit aggravated child abuse, facilitation of attempt to commit aggravated child abuse, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child abuse, attempt to commit child abuse, assault, and attempt to commit assault. Count 5 of the presentment charges the defendant Megan Boswell with the offense of aggravated child neglect. This offense embraces the lesser included offense of facilitation of aggravated child neglect, attempt to commit aggravated child neglect, facilitation of attempt to commit aggravated child neglect, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child neglect, attempt to commit child neglect, assault, attempt to commit assault. Count 6 of the presentment charges the defendant Megan Boswell with the offense of tampering with evidence. This offense embraces the lesser included offense of facilitation of tampering with evidence, attempt to commit tampering with evidence, and facilitation of attempt to commit tampering with evidence. Count 7 through 17 of the presentment charges the defendant with Megan Boswell with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant, Megan Boswell, with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant, Megan Boswell, with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. The question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if, in fact, such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense. Count 2, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. the killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix the fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the aggravated child neglect, the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And 3, excuse me, 3, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally have previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony and was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you will so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown or established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix a fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has previously been defined for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of the instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix a fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury, and 2, that the act of abuse resulted in serious bodily injury to the child, and 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For purposes of this count, intentionally, knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have a reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than not greater than $5,000. And you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty of this as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5, misdemeanor reckless endangerment. Any person who commits the offense of misdemeanor reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of misdemeanor reckless endangerment as charged in the presentment, then your verdict must be not guilty as to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. That should say neglect. All right, let me reread that. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix the fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew an investigation was in progress, and 2, that the defendant concealed a thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, knew, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of tampering with evidence as charged in the presentment, then your verdict must be not guilty as to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officer is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the statement was made by the defendant. 2, that statement was made in response to a legitimate inquiry by a law enforcement officer. And 3, that the statement would concern a material fact about an incident within the officer's concern. And 4, that the defendant knew such statement was false. And 5, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur. For purposes of this count, new and law enforcement officer are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false report, then you may fix the fine in any amount not greater than $5,000, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt in a false report as charged in the presentment, then your verdict must be not guilty as to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of abuse of a corpse, then you may fix a fine in any amount not greater than $3,000. You'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of a corpse as charged in the presentment, then your verdict must be not guilty as to this offense. Count 20. Failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly failed to report the death of Evelyn Boswell to the county medical examiner, local police, district attorney, or sheriff. And 2, that the death was from violence, trauma, or any suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under circumstances as the defendant believed them to be at the time. And his actions constitute a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4. Attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5. Attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count 6. Attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17, attempt to commit false report, maximum fine $5,000. Count 19, attempt to commit abuse of corpse, maximum fine $2,500. Count 20, attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1, facilitation of first-degree murder, maximum fine $50,000. Facilitation of attempt to commit first-degree murder, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6, facilitation of tampering with evidence, maximum fine $5,000. Facilitation of attempt to commit tampering with evidence, maximum fine $3,000. Count 19, facilitation of abuse of the corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense are circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or new means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Recklessly or reckless means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as to the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense, and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Child neglect. 19. Attempt to commit child abuse. 20. Attempt to commit child neglect. 21. Assault. 22. Attempt to commit assault. 23. Misdemeanor reckless endangerment. Count 2. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Attempt to commit child abuse. 19. Assault. 20. Attempt to commit assault. 21. Misdemeanor reckless endangerment. Count 3. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child neglect. 18. Attempt to commit child neglect. 19. Assault. 20. Attempt to commit assault. 21. Misdemeanor reckless endangerment. Count 4. 1. Aggravated child abuse. 2. Facilitation of aggravated child abuse. 3. Attempt to commit aggravated child abuse. 4. Facilitation of attempt to commit aggravated child abuse. 5. Aggravated assault. 6. Facilitation of aggravated assault. 7. Attempt to commit aggravated assault. 8. Facilitation of attempt to commit aggravated assault. 9. Reckless aggravated assault. 10. Facilitation of reckless aggravated assault. 11. Assault. 12. Attempt to commit assault. 13. Misdemeanor reckless endangerment. 14. Child abuse. 15. Attempt to commit child abuse. Count 5. 1. Aggravated child neglect. 2. Facilitation of aggravated child neglect. 3. Attempt to commit aggravated child neglect. 4. Facilitation of attempt to commit aggravated child neglect. 5. Aggravated assault. 6. Facilitation of aggravated assault. 7. Attempt to commit aggravated assault. 8. Facilitation of attempt to commit aggravated assault. 9. Reckless aggravated assault. 10. Facilitation of reckless aggravated assault. 11. Assault. 12. Attempt to commit assault. 13. Misdemeanor reckless endangerment. 14. Child neglect. 15. Attempt to commit child neglect. Count 6. 1. Tampering with evidence. 2. Facilitation of tampering with evidence. 3. Attempt to commit tampering with evidence. 4. Facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17 1, false report. 2, attempt to commit false report. Count 19, 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20, 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second? Now, ladies and gentlemen, remember, when you go back there and you select a four-person, this is the official jury charge, okay? And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment at a separate sentencing hearing. You'll be provided with forms for all possible verdicts in this case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. Now, in your books, you don't have, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant Megan Boswell marked the appropriate one. Checkbox 1, guilty of first-degree murder, or checkbox 2, guilty of facilitation of first-degree murder. Fine amount $sign blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder. Fine amount $sign blank, not more than $50,000. Or checkbox 4, guilty of guilty of facilitation of attempt to commit first-degree murder. Fine amount $sign blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount $sign blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder. Fine amount $sign blank, not more than $25,000. Verdict form, count 1 continued. Checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $sign blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $sign blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $sign blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $sign blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount $sign blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount $sign blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount $sign blank, not more than $5,000. Or checkbox 14, guilty of facilitation of reckless homicide. Fine amount $sign blank, not more than $3,000. Excuse me. Or verdict form count 1 continued. Checkbox 15, guilty of criminally negligent homicide. Fine amount $sign blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount $sign blank, not more than $2,500. Or checkbox 17, guilty of child abuse. Fine amount $sign blank, not more than $2,500. Or checkbox 18, guilty of child neglect. Fine amount $sign blank, not more than $2,500. Or checkbox 19, guilty of attempt to commit child abuse. Fine amount $sign blank, not more than $500. Or checkbox 20, guilty of attempt to commit child neglect. Fine amount $sign blank, not more than $500. Or checkbox 21, guilty of assault. Fine amount $sign blank, not more than $2,500. Or checkbox 22, guilty of attempt to commit assault. Fine amount $sign blank, not more than $500. Or verdict form count 1 continued. Checkbox 23, guilty of misdemeanor reckless endangerment. Fine amount $sign blank, not more than $2,500. Or checkbox 24, not guilty. Four-person signature line date blank. Verdict form count 2. With jury, find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of first-degree murder in the perpetration of a felony. Or checkbox 2, guilty of facilitation of first-degree murder in the perpetration of a felony. Fine amount $sign blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder in the perpetration of a felony. Fine amount $sign blank, not more than $50,000. Or checkbox 4, guilty of facilitation of attempt to commit first-degree murder in the perpetration of a felony. Fine amount $sign blank, not more than $25,000. Or checkbox 5, guilty of second degree murder, find amount of dollar sign blank, not more than 50,000, or verdict form count 2 continued, checkbox 6, guilty of facilitation of second degree murder, find amount of dollar sign blank, not more than 25,000, or checkbox 7, guilty of attempt to commit second degree murder, find amount of dollar sign blank, not more than 25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, find amount of dollar sign blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, find amount of dollar sign blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, find amount of dollar sign blank, not more than $5,000. Checkbox 11, guilty of attempt to commit voluntary manslaughter, find amount of dollar sign blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, find amount of dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, find amount of dollar sign blank, not more than $5,000, or verdict form count 2 continued. Checkbox 14, guilty of facilitation of reckless homicide, find amount of dollar sign blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, find amount of dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, find amount of dollar sign blank, not more than $2,500, or checkbox 17, guilty of child abuse, find amount of dollar sign blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child abuse, find amount of dollar sign blank, not more than $500, or checkbox 19, guilty of assault, find amount of dollar sign blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault, find amount of dollar sign blank, not more than $500, or verdict form count 2 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, find amount of dollar sign blank, not more than $2,500, or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 3. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of first degree murder and perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder and perpetration of a felony. Find amount of dollar sign blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder and perpetration of a felony. Find amount of dollar sign blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony. Find amount of dollar sign blank, not more than $25,000, or checkbox 5, guilty of second degree murder. Find amount of dollar sign blank, not more than $50,000, or verdict form count 3 continued. Checkbox 6, guilty of facilitation of second degree murder. Find amount of dollar sign blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder. Find amount of dollar sign blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder. Find amount of dollar sign blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter. Find amount of dollar sign blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter. Find amount of dollar sign blank, not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter. Find amount of dollar sign blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Find amount of dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide. Find amount of dollar sign blank, not more than $5,000, or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide. Find amount of dollar sign blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide. Find amount of dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide. Find amount of dollar sign blank, not more than $2,500, or checkbox 17, guilty of child neglect. Find amount of dollar sign blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child neglect. Find amount of dollar sign blank, not more than $500, or checkbox 19, guilty of assault. Find amount of dollar sign blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault. Find amount of dollar sign blank, not more than $500, or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment. Find amount of dollar sign blank, not more than $2,500, or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 4, we, the jury, find the defendant, Megan Boswell, mark appropriate 1. Checkbox 1, guilty of aggravated child abuse. Find amount of dollar sign blank, not more than $50,000, or checkbox 2, guilty of facilitation of aggravated child abuse. Find amount of dollar sign blank, not more than $25,000, or checkbox 3, guilty of attempt to commit aggravated child abuse. Find amount of dollar sign blank, not more than $25,000, or checkbox 4, guilty of facilitation of attempt to commit aggravated child abuse. Find amount of dollar sign blank, not more than $10,000, or Checkbox 5, guilty of aggravated assault, not more than, fine amount, dollar sign blank, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault, fine amount, dollar sign blank, not more than $5,000. Or verdict form count 4 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount, dollar sign blank, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit aggravated assault, fine amount, dollar sign blank, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault, fine amount, dollar sign blank, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault, fine amount, dollar sign blank, not more than $3,000. Or checkbox 11, guilty of assault, fine amount, dollar sign blank, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault, fine amount, dollar sign blank, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount, dollar sign blank, not more than $2,500. Or checkbox 14, guilty of child abuse, fine amount, dollar sign blank, not more than $2,500. Or verdict form count 4 continued. Checkbox 15, guilty of attempt to commit child abuse, fine amount, dollar sign blank, not more than $500. Or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 5. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of aggravated child neglect, fine amount, dollar sign blank, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated neglect, fine amount, dollar sign blank, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child neglect, fine amount, dollar sign blank, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect, fine amount, dollar sign blank, not more than $10,000. Or checkbox 5, guilty of aggravated assault, fine amount, dollar sign blank, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault, fine amount, dollar sign blank, not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount, dollar sign blank, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault, fine amount, dollar sign blank, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault, fine in amount, dollar sign blank, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault, fine amount, dollar sign blank, not more than $3,000. Or checkbox number 11, guilty of assault, fine in amount, dollar sign blank, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault, fine amount, dollar sign blank, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount, dollar sign blank, not more than $2,500. Or checkbox 14, guilty of child neglect, fine amount, dollar sign blank, not more than $2,500. Or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect, fine amount, dollar sign blank, not more than $500. Or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 6. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of tampering with evidence, fine amount, dollar sign blank, not more than $10,000. Or checkbox 2, guilty of facilitation of tampering with evidence, checkbox amount, dollar sign blank, not more than $5,000. Or checkbox 3, guilty of attempt to commit tampering with evidence, fine amount, dollar sign blank, not more than $5,000. Or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence, fine amount, dollar sign blank, not more than $3,000. Or checkbox 5, not guilty, 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of false report, fine amount, dollar sign blank, not more than $5,000. Or checkbox 2, guilty of attempt to commit false report, fine amount, dollar sign blank, not more than $3,000. Or checkbox 3, not guilty, 4-person signature line date blank. Verdict form count 19. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of abuse of a corpse, fine amount, dollar sign blank, not more than $3,000. Or checkbox 2, guilty of facilitation of abuse of a corpse, fine amount, dollar sign blank, not more than $2,500. Or checkbox 3, guilty of attempt to abuse a corpse, fine amount, dollar sign blank, not more than $2,500. Or checkbox 4, guilty of facilitation of attempt to commit abuse of a corpse, fine amount, dollar sign blank, not more than $500. Or checkbox 5, not guilty, 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant, Megan Boswell, mark the appropriate one. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances. Find amount $ blank, not more than $3,000. Or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. Find amount $ blank, not more than $2,500. Or checkbox 3, not guilty. 4-person signature line date blank. Back on page 48. You'll be provided with, well, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. I'm going to stop right there. Is there lunch here? Your lunch is here. I'm going to let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm going to have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge.
Everyone stand, please.
Hello, this is Dr. Grande. Today I will analyze the case of Melanie and David Clark. First, I'll look at the background of this case, move to the timeline of the crime, then offer my analysis. Melanie Clark was born in the mid-1970s and raised in South Africa. As an adult, she was involved in romantic relationships and had 4 children. When she was going through a divorce, she reconnected with a military medic named David Clark. They had originally met when they were children. David was also going through a divorce. In 2005, Melanie and David married, and David raised Melanie's children as his own. In 2011, the family moved to Britain and lived in a house in Stoke Prior, which is 23 miles south of Birmingham. They made this move because they were worried about the high level of crime in South Africa. David started working as an estate agent, which is essentially the same thing as a real estate agent in the United States. Now moving to the timeline of the crime. On December 31, 2017, New Year's Eve, at 11:51 p.m., David Clark called emergency services and said to the operator, quote, "I am sorry, I have killed my wife," unquote. He indicated that he loved and hated his wife. David said, quote, "I can't believe I blanking did it. I am blanking devastated. I don't know why I did it," unquote. The police arrived at the Clark family house at 12:03 a.m., now on January 1, 2018. They found David on the side of his house in his pajamas. There was blood on his hands and on his clothing. Another officer went upstairs and found Melanie Clark dead in a bedroom from a stab wound to the chest. She did not have any defensive injuries. David Clark was arrested and charged with murder. Here is what the police found during the course of their investigation. The problems that led to Melanie's death developed over the course of a few years. Starting in 2015, the romantic relationship between Melanie and David became acrimonious and dysfunctional. They were on again, off again. Toward the end of 2015 and in the early part of 2016, David came to believe that Melanie was having an affair with a woman. At various points, David moved out of the family home, but moved back in each time. The marriage became even worse in November and December 2016. David started using dating websites and did not make an effort to hide it from Melanie. He met a woman named Julie, and they had a brief romantic relationship. David had this affair specifically to make Melanie jealous, and his tactic was successful. Melanie and David separated again, and David was supposed to move out by mid-December 2016. In early December, David called the police and said that his wife Melanie had threatened to slash him with a knife. The police investigated but did not see any reason to believe that David was telling the truth. The next day, David took pills as if he might be trying to harm himself. In response, Melanie called emergency services. On December 14, David pushed Melanie out of bed, which caused bruises on her. No arrests were made. 2 days later, David's lover Julie came to the Clark family house. When David decided to remain with his wife, Julie realized that she had been used by David. By the end of December 2016, Melanie and David decided to reconcile. David spent Christmas at the family home. In April 2017, David moved back into the family home full-time. He stayed in a small bedroom, which had been occupied by Melanie's youngest daughter, who returned to South Africa to live with her father. David kept silverware, including kitchen knives, in his bedroom. By the end of November 2017, the marriage between Melanie and David had once again deteriorated. During this sensitive time, an incident occurred which put even more stress on the marriage. David had a best friend named Stephen. Stephen had a 30-year-old daughter named Katie. On December 28, 2017, Stephen and Katie paid a visit to the Clark family house. They had dinner there and ended up staying the night. At around midnight, Melanie and Katie went upstairs. David claimed that he heard the women giggling and talking. Whatever they did or did not do in that bedroom on December 28, the next day, Melanie led David to believe that she had a sexual encounter with Katie. Melanie was feeling guilty and embarrassed about this interaction. This wasn't something that she was proud of or bragging about. She made David promise not to tell family or friends about what she did. Melanie and David had sex that day, perhaps as a symbol of reconciliation. On New Year's Eve, the couple spent time at a house occupied by their friends, Philip and Nadia. The couple appeared to have a good time. They consumed alcohol and played various card and board games. It didn't take too long for Melanie and David to find themselves heavily intoxicated. Melanie ordered a taxi to transport her and David back to the Clark family home. They departed the residence of Philip and Nadia at 10:30 p.m. and arrived at their home at 10:44 p.m. Over the next hour, Melanie and David engaged in a dramatic and ferocious argument, which took place verbally and through a series of WhatsApp and text messages. Just before 11 p.m., David attempted to send a message to his friend Stephen, explaining how Stephen's daughter Katie had an alleged sexual encounter with Melanie. David sent a copy of this message to Melanie. It was clear that David was trying to aggravate and hurt his wife. He knew this alleged sexual encounter with Katie was a source of embarrassment for Melanie. At 11:12 p.m., Melanie sent David a message which read, "Katie is great, she is awesome." At 11:23 p.m., Melanie sent a message telling David that she wanted him out of the house by 10 a.m. the following morning. David attempted to resend the message to Stephen, again the message about Melanie and Katie allegedly having sex. He also forwarded this message to his sister and to one of Melanie's sons. David sent a message to Melanie saying that he informed others, although he didn't know that at the time because no one had answered his messages. He could not be sure if the messages went through or not. At 11:43 p.m., Melanie sent David a message which read, quote, "They laughing at you, David, have been for the last 10 years, unquote." She repeated her demand that David leave the house in the morning and threatened to call the police if he was still around. At 11:48 p.m., Melanie sent David several emojis mocking him. Sometime during the next 2 minutes, David retrieved one of the kitchen knives which he had in the small bedroom, walked into the main bedroom where Melanie was, and stabbed her once in the chest. At 11:51 p.m., David called emergency services, as I mentioned. Later, he was arrested and charged with murder. There was no question that David killed Melanie, and there was no question a crime was committed. The issue was about the level of severity. The Crown argued that David committed murder. David's defense argued that he committed manslaughter by loss of control. David went to trial. On June 27, 2018, he was found guilty of murder. About 2 weeks later, on July 12, David Clark was sentenced to life in prison with the possibility of parole after 15 years. When considering time served, he could be released in 14 and a half years. Now moving to my analysis. As I mentioned, the issue at trial was not guilt or innocence, but rather murder or manslaughter by loss of control. The loss of control defense is considered a partial defense to murder. The idea is that a person killed another after being provoked. An individual of normal tolerance and self-restraint would have acted similarly if they were in the same situation as the defendant. This brings me to the question, was David guilty of murder? Let's take a look at the evidence both for and against the idea that he was guilty, starting with the inculpatory factors. In the hours leading up to the killing, David deliberately tried to irritate his wife by exposing her alleged affair. Melanie did not respond to all the messages that David sent that night. This made it seem like David was the one provoking, not Melanie. David retrieved a knife from his bedroom, walked to his wife's bedroom, and stabbed her one time in the chest. It wasn't like he had the knife in his possession when they were arguing. He took the knife to his wife and killed her with it. This makes the killing seem planned. David was under the influence of alcohol when he killed his wife, about 2 times the legal limit for driving in Britain. This may have lowered his inhibitions, but that is not a defense to murder. David claimed that he had no memory of events which occurred after the last exchange of messages, which seems incredibly convenient under the circumstances. There is no question that during the history of the marriage, Melanie behaved badly, but so did David. David was described as obsessive, regimented, and perfectionistic. He organized everything in his life and wanted it to be in the right place. For instance, he arranged his shirts by color. Here are just a few of the bad behaviors that David allegedly exhibited during the marriage. He would sometimes fly into a rage and become physically threatening. He would yell at Melanie's children if they left a door open. He called one of her sons a fat blank. The blank rhymes with brick. He used the C word to refer to Melanie's youngest daughter. This is one of the reasons her daughter moved back to South Africa. And David had at least 2 affairs. In early 2017, Melanie was concerned about David having affairs and wanted to monitor his electronic devices. She was tired of his infidelity and demanded that he stop. This makes it seem as though Melanie was the one trying to make the marriage work. Moving to the exculpatory factors, David stabbed his wife 1 time and immediately called emergency services. An intent to kill would be more consistent with stabbing multiple times and waiting before notifying the authorities. David's behavior was consistent with the idea that Melanie was provoking him, and he just wanted her to stop, rather than possessing a desire for her to be dead. Just 3 minutes before Melanie was killed, she sent emojis to David, mocking him. At David's sentencing, the judge indicated that David was a man of good character who did not premeditate the murder. In the years leading up to the killing, Melanie's behavior was aggressive and mean-spirited. According to David, she would drink alcohol almost every night. When she was drinking, she was not pleasant to be around. Melanie frequently directed expletives toward David. She would criticize, belittle, and humiliate him. According to David, Melanie frequently offered commentary about his genitals, saying that his member was undersized. This caused David to feel inadequate, sad, and like he was not a man. Melanie took advantage of David's obsessiveness to aggravate him. She would deliberately move his property around so he could not find it. For instance, she would mix up his work shirts. When considering all the evidence in this case, do I think that David Clark was guilty of murder? Yes, I believe he was guilty beyond a reasonable doubt. Melanie might have deliberately aggravated David right before she died, but David was being at least equally as antagonistic. He was looking to cause a major fight. When Melanie ignored some of David's messages and went to bed, she was signaling her intent to disengage from the argument, or at least not to escalate it. David is the one who escalated the situation by retrieving a knife and stabbing Melanie to death. What do I think happened in this case? This is just a theory, my opinion. David Clark was self-centered, impulsive, angry, antagonistic, demanding, controlling, manipulative, obsessive, perfectionistic, rigid, and had a sense of entitlement. He would not tolerate any deviation from his expectations. David demanded that everything go his way. When Melanie had her alleged sexual encounter with Katie, this threw David into a tailspin. This eroded his sense of control in the marriage. David believed that he should be allowed to cheat, but Melanie was not granted the same privilege. On the night of the murder, the couple started arguing. David tried to use Melanie's alleged affair as ammunition against her, but this tactic was not successful. Melanie didn't really care. She had enough of David and told him that he better leave the house in the morning. David could not tolerate losing all his power. Therefore, he regained it in the form of murder. There was just no way he was going to let Melanie win. David did not lose control and commit manslaughter. Rather, he killed because he feared losing control of his wife. After being arrested, David focused on Melanie's bad behavior as an excuse for murder. He thought that people would be mesmerized by his monologue of Melanie's miniature manhood manifesto. As it turns out, just like Melanie was not impressed with David's genitals, the jury was not impressed by his story. Those are my thoughts in the case of Melanie and David Clark. Thank you so much for watching. I'll talk to you soon. Oh, this is Dr. Grande. Today,
Those of you standing on the back wall, I can see you very
You mean like this is a table across it? No, I'm not gonna do that. I thought you meant don't step back over there. Okay, I thought, I misunderstood you. Oh. Well, the problem is that laser pointer, because it's made for LCD screens, it'll bounce off.
No, no, I didn't.
Yeah. Yeah. Well, practice it, make sure it works, and if it's hitting the wall over there, we're not trying to keep it. She sure did. Including, you know.
All right. Is the state ready to proceed with closing?
Yes, Your Honor.
Defense ready?
Yes, sir.
If the jury's ready, let's bring them in. Now, I am going to say, hey, Kyle, hold on.
Okay.
Sorry. Let me put this down here so y'all can hear me. Can everybody hear me? If there is any outbursts at any time during the state's closing, the defendant's closing, the state's rebuttal, I'll clear the whole courtroom. All right? Now we go to the jury. You've got exhibits 1 through 5 and 93 separated, right? 93 also? Yes. Okay.
I need exhibit number 183. It's a video.
It's bagged by one of the security officers. Huh?
That was my blood sugar alarm. It went up high. Everyone stand, please.
My dad. I need I'm going to leave this up if that's okay, Your Honor. Thank you. So we've finally reached the point in trial for closing arguments. And what this essentially means is it's an opportunity for the state of Tennessee to go through, talk about the evidence a little bit, reflect on some of the witnesses, because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6, it covers the burden of proof. And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay? My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. They might be on that same page. Probably should have written it. Here it is, page 5. In your instructions, in the second paragraph, it states, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. He kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, but the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, John.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also can make mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you. Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case. Mr. Scott brought up the theory of an accident, or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence,
tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the chicken shack, to December 8th. Evelyn Boswell's 12-month well visit. Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows. And Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse, I can't remember what it was, as to why she couldn't bring her. So they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by. Because I know that's a question we have all had. 2.5 months goes by. 2.5 months. But now we know. We know why. Because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But, time continues to pass, and you've heard witnesses, and particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think like something doesn't feel right. Just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day. And Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood. And Megan Boswell's there. But there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory box. Now, why would you call something a memory box if you were alleging that your child is still alive? This is all Megan Boswell had of Evelyn in that house. house that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger, not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house. Now, I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back and trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy. And so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. Mr. Scott wants you to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell, because she would not go to school. She went to foster care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with her mommy, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated there are, maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell, the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell. And I'll submit to you that Hunter Wood, the person that they would like to blame somehow, is also a victim of Megan Boswell. She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different. Then she goes to her mom. She blames her mom, her own mother. She's willing to blame All the time knowing. I mean, we know. Let's find the picture. We know where Evelyn was. There she is. Evelyn Boswell sat there in that trash can for 2.5 months. And her mom discarded her, not just Evelyn, but everything that was associated with Evelyn. Everything. Because she didn't need it anymore. Everything. She didn't need that stroller anymore, so she left it behind. She didn't need the clothing. Do you remember all the pictures that came in and all of that stuff that was in that shed? Because she didn't need it anymore, because she knew where Evelyn was. The defense wants you to believe that Hunter Wood is the one that backed Megan's car up to that shed in the middle of the day. In the middle of the day, Hunter's just going to go over there. He has a truck. The testimony was that Hunter had a big truck. Now, why in the world, if he had a truck? I mean, this clearly took more than one trip. I guarantee you. Look at all this stuff. They want you to believe that Hunter Wood backed Megan Boswell's car up to that shed that day. Tommy came home. It was in the middle of the day. Where's the diagram? Do you remember the diagram of the scene? Look at this diagram. They somehow want you to believe that Hunter Wood pulls up this driveway and comes to this shed right here, right in front of Omani's house. Tommy's house up on the hill in the middle of the day. Is that reasonable? What is reasonable? How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed, because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Omami's house. And so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. It's Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind, the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And it's not a very nice statement to begin with, but it's definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand and you heard Megan Boswell admit that she knew Evelyn was dead. She was telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, what's your point? What's your point? And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. a mess of these. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment? And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with them. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. Think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life. As if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she sat here when she's picking out furniture for their new house? That she's sad today? She has the gall to sit here and cry today and pretend she can't look at the pictures of what she did to her child? What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can. She's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing, still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things? You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA, let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you can look at them when you get back there, and then dispose of them in the same trash can that the baby's in. That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell, that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory. Or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please? Thank you. Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Of course, he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it under the rim? Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag? Megan Boswell's fingerprints. And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag. And it was forcefully pushed down. Compressed, I think is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag. Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on that foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash. Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if the child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malishnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide and that Evelyn Boswell died from some sort of asphyxiation. So suffocation, I guess, is the easiest way to say it. So if it was not for, say, the position of her body upside down in the trash can, that could have killed her. We'll say it wasn't that. Then maybe it was the blanket that was pulled up over. Remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can. Could have also been the trash bag that she was placed inside of, where she was unable to breathe. Could have been the foil that was wrapped around her head. Could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve, to where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body down into the trash can. Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil on her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count one, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser included offenses, and we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these. Again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form. The state has to prove several elements for each charge, and those are also in your packet. Count one is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil, or premeditation in the time that she put her in that trash bag, or premeditation in the time that she pushed the next trash bag on top of her body. Ladies and gentlemen, I submit to you, there is nothing about this case that is not premeditated. Count two and count three are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. we submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can. That's neglect. Leaving her in the trash can, that's abuse. And it resulted in her death, which is felony murder. And we have to prove that the child was under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. And if you remember, the defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her. You heard from the witness stand, there were people that she could have given Evelyn to that would have given her a beautiful life. But instead, she violently murdered her daughter. She told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you the state has proven every count and every element of every count beyond a reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you, General. Mr. Scott, you may close.
Good afternoon. I appreciate y'all's time. Appreciate you being here. Although I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case. And Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. Jury instructions will tell you that this case is not about your emotion. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute. But the state seems to be putting forth the theory that you should convict her of first-degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also technically would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page for page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well checks. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect. We heard from Audrey Gibbs. She'd been with Megan almost every day up until she moved to Knoxville in 2019. She describes Megan as a good mom. There were a few things. There was once where she thought her diaper needed to be changed. Once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville at the end of December sometime, and by that point she acts disassociated. She's not normal. She's saying "I love you" over and over again to her. So, again, maybe she's not grieving right. Bailey Hawkins stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things. They might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did. There's video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about a home life? Watch the video with Agent Fraley. Her mom was let in there in stripes, a jail uniform. What kind of home life was that? And then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, that Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name is, I can't remember his name honestly. That's the mother of his ex-boyfriend. She described Megan as a good mother. Evelyn was always clean. And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb, Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out on anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso till I see his car in the parking lot, pull in. That's not what happened. I think he kind of wanted you to think that, but that's not what happened. Let's talk about Randy Wood. Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunter Wood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massengill wants you to think I have some grand conspiracy theory. I don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swaddled her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible. Why did Hunter not give his DNA? Ask yourself that. If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they had? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he says, yeah, he talks about some off-the-wall stuff. Now, ask yourself, who's more likely to wrap that child in tinfoil? The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic? And I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. The young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Smith and Dr. Malushnik. Now, Dr. Smith asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And the diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malushnik, I didn't ask about something that didn't exist. Dr. Smith knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive and dead. She couldn't say that. She brought up that the child had a heart valve that leaked. She admitted under cross-examination that could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massagill brought up tongue tie. I brought up tongue tie. I brought up GERD. I brought up an infection she had, because all of those things can lead to the onset of SIDS. That's the research, and Dr. Smith agreed with that. Now, I want to tell you something about Dr. Smith and Dr. Malushnik. I think Dr. Smith she was the medical examiner in Johnson City when this happened. Dr. Malushnik is not her boss. She's not, it's not like she's somehow over her. Dr. Smith was the chief medical examiner at the Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malushnik for another opinion. Dr. Malushnik only reviewed her report, and she finds that it's a good report. But then she wants to go further and find with some type of certainty that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened she would be in contempt if she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left. And suggest to you the more accuracy of that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear. She could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. McLuhan come in with a preconceived notion of that's what happened. Now, the state has to prove to you cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Schmidt leaves open a heart, it leaves open SIDS, laryngeal convulsion, it leaves open all of those things. We don't know what happened. It also left open a rollover, which is what Megan told Agent Fraley. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble. And that's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No, it's not. Should she have called and reported? She absolutely should have. I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point. That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how they grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up. She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought two medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about them. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness. Now, let's talk about the tinfoil. How can her one fingerprint be on a piece of tinfoil? You all see this roll? Maybe like this. Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way. What's another possible way? We've heard that the tinfoil had food and debris on it. Now, there was food and debris in the trash can. But maybe the tinfoil was already thrown away in the trash can. If it came off of a roll like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it. One fingerprint. One fingerprint. It doesn't prove she put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen. Your DNA is all over the house. Your finger, I said DNA, actually it's fingerprint. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think that's what you should consider. I mean, probably Evelyn's handprint on the trash can. At some point, I think in opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's a child's. Now, Ms. Maxengill made a statement. I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint experts say that it can't. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement of Agent Fraley. February the 25th. She's talked to law enforcement over and over. And she talks about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's. It could be at Tommy's. Why would you say, if you're trying to lie to them, perpetuate this lie like Miss Maxengill tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's telling them where the baby is. She thinks, I think it could have been left one of these 2 places because I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven the cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some rolling over in the bed being an accident, or some kind of health-related issue. They haven't proved that. Let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Massengill talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look to your notes, TBI cut those gloves up for testing. I could be wrong, but I think that's the case. And what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter. And it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at the texts. They're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child. But I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to have proof that you didn't do something, if you start a conversation, start texting it, say, oh no, I didn't do that. Look at my text. I texted her. She's told me this. It's a convenient thing for him. But he didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your questions. I hope my argument has helped you somehow with this case. But what I would say to you, if you have questions, about any of the elements of these crimes, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt on the homicide count. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons. I'm used to it. I think I've been up here for about a half an hour, but I thank you. I pray you'll come to the right decision. Thank you.
Thank you, Mr. Scott. General, you may close on behalf of the state.
Thank you, Judge. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient
explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. Truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends. Every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, you could, that was the point, which she decided, hey, I'm going to be truthful here. No, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. So they're the ones who suggested it. And then very conveniently the next day she comes in and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected him. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this just pattern of just totally bizarre behavior that involves wrapping her child in a blanket,
tightly pressing her head in aluminum foil and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence, isn't it, that all this occurs at the same time that she starts working at the chicken shack. And then she meets Hunter Wood. You know, that Hunter Wood, the one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. Remember the other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. Wanted Ethan Perry to step up. I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common sense in asking yourselves why. Why would Megan Boswell then start on December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December 7th. Remember, she starts Chicken Shack the 2nd, 7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have her. Evelyn's sick. She's got the flu. I can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend Bailey Hawkins told you, I mean, yeah, she wasn't a perfect mom, but she did well. She did well. They all did. I mean, she's posting pictures on Facebook, Instagram. Everybody. Her own pediatrician, Dr. Pugh, came in here. Yeah. She's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, that's an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her. She won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Why? Apply your common sense. She won't do it because she can't face the truth about what she's done. She can't face that truth. She can't look at that picture. And I'm not going to put it back up there for you. She can't face what she's done to that child. Discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting that out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one. And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand and said, oh yeah, I remember when I saw Hunter and Evelyn and Megan together. I remember when I saw that. None. Nobody said that. How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No. Again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember. But that's what she wants you to believe. When her breaking point, when she's finally telling the truth. Apply your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed? Well, maybe it's the playhouse over on Tommy's property. No. Again, we know Evelyn is probably gone 5 days after she first met Hunter from working at the chicken shack. But Megan Boswell wants you to believe that he's been able to go onto her property and stick a body in a trash can in a playhouse that was built for Megan Boswell. Mr. Scott asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here, and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier, and in doing that, she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension that we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it. Maybe that's why. And again, in this particular case, you heard from Agent Gray. What does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her, she analyzed. Not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. As I remember, I asked her if I gave everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter Wood. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things that medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just 2 doctors about Evelyn's condition, about what kind of a child she was. You heard from 3 doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No, her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern, not Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who died in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet they want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently, the first one. No, it's not a possibility. You decide this case on the evidence that you've heard, the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners said this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. All the evidence in this case points to one person alone as being the person who caused that asphyxiation. And that is Megan Boswell. This wasn't an accident, ladies and gentlemen. It wasn't an accident at all. You've got lots of evidence of premeditation sitting over there in that box. This isn't a little piece of tin foil. This isn't foil like you stick around a baked potato and stick in the oven. You saw it. You saw the photographs, and the foil's in there. Pull it out. It's a big old piece of foil. Mr. Scott wants to suggest maybe it's sitting down in the trash can. Somebody pulled it out. Nobody's using that much foil. Use your common sense. And remember the testimony from Dr. Malusnik yesterday about how that foil was applied. That blanket, so tight when they're taking it off, the impressions left on that child's face. The foil, how painstakingly slow they had to pull it off because it was tightly compressed around the child's head. I submit to you, that's premeditation, ladies and gentlemen. That's intent. That's not an accident. Part of this case, ladies and gentlemen, that Mr. Scott said is really, sad. It really is. It's a tragedy. You think about all those people that you heard testify, how easily all of this could have been avoided. All those people, Bailey Hawkins, Audrey Gibbs, Casey Saltz, Gail Kite, Paul Miller, Erica Stacy. Any one of those people would have taken that child. All this could have been avoided. But Megan Boswell only cares about one person, and that's Megan Boswell. She started a facade back first week of December after she killed her child. She created this world, this web, you've heard it called. That's a pretty good description of it. It's a web. It traps and ensnares everybody that she comes into contact with. She started this facade back then, and it's continued and continued and continued. And she brought it into here to this courtroom in front of you. And she's trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It's an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could do Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium, Super Bowl party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there to take a harass the James Lewis interview. She acted all surprised. What are y'all going to do? You going to find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions, for her decision to get rid of Evelyn, to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell was guilty, first-degree murder, false report, tampering with evidence, and failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, John. Let us see the attorneys. Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. If you will go with the officer. Just leave them in the seat. That'd be fine. And your notes as well. We'll just take care of them. The rest, what do you mean? Yeah, I'm going to finish the charge. All right. Now, back on page 49. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. Take with you the presentment, the exhibits, the verdict forms, the court's written instructions, and you may retire and consider your verdict as soon as the officer comes back to get you.
Everyone stand, please.
305 PM. the ones that you have. Just
Right.
the three.
Leave the others.
That's what we should be looking, don't worry about the ones that belong to us. Okay?
I've been working in the background, Don, working hard.
Maybe see, thank you.
All right, we'll be in recess, waiting
Okay.
verdict of the jury.
So that's it. Deliberations begin. And we are officially on verdict watch. I don't believe. So what's the time over there now? 4:08 p.m. I reckon at the latest by tomorrow night. That's just me though. 3:08. Okay, well, let's still got a couple of hours. They're sequestered too, aren't they? So they can stay quite late if they need to. Well then. The results of the poll, they should be up in chat, but let me see. Okay, so 69% of you all said guilty to murder 1 and the additional. 30% said guilty, but of the lesser included of murder 2 with the extras. And no one believes there's going to be a hung jury or a not guilty count. Vote. So there you go. Doesn't let me vote, unfortunately. Never mind. Alrighty, what's today? Wednesday? Thursday for me. Wednesday? Yeah, Thursday. Oh, Lord. So, what to do tomorrow night? I'll think of something, don't you worry. I'll think of something. So make sure you've got those notification button turned on, because I could pop up at any time with anything. You know me. Anytime's a good time. All right, my darlings. Thank you for joining me. Thank you for watching. And remember, justice isn't deaf. It's just waiting for you to hear it. Have a good one. See you next time. Bye-bye.
Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.